So, let us look into how this provisions of the writs has come to Indian legal system. As the British invaded into India and we have become a colony of British, the writ jurisdiction could be, we could see the origin of the writ jurisdiction we could attribute to the Regulating Act 1773, because this Regulating Act 1773 established Supreme Court at Calcutta, and then the Charter 1774 empowered the Supreme Court to issue writs. So, therefore, the writ jurisdiction started in India from 1774, I am sorry, and it was enjoyed by the Supreme Court in Kolkata. However, in 1801 and 1823, the two Supreme Courts were established in Madras and Bombay respectively. That means, in 1801 in Madras and 1823 in Bombay, two more Supreme Courts were established, and both courts were conferred with the writ jurisdiction. However, the High Courts Act 1861 established the High Court, replacing all these three Supreme Courts. As the High Courts were established to replace the Supreme Court, all the powers exercised by the Supreme Court was transferred to these three High Courts, and as a result, even the writ jurisdiction was transferred to these three High Courts. So, therefore, these three High Courts in Calcutta, Madras and Bombay used to exercise the writ jurisdiction. However, this was not so in case of other High Courts established under the same Act in other parts of the country. That means, only among the High Courts established after 1861 Act, only these three High Courts are exercising the writ jurisdiction, because they inherited the jurisdiction from the Supreme Court, but the remaining High Courts did not inherit such jurisdiction, therefore, they are not allowed to exercise the writ jurisdiction. And these three courts, even though exercising the writ jurisdiction, it was restricted only to the original suit under the Specific Relief Act. That means, the power to issue the writs are essentially restricted to those three courts, and even these three courts also could issue writs only in case of Specific Relief Act under the original civil jurisdiction. That means, during the British India, the exercising of the writ jurisdiction are conferred only to three courts, and also for a very, very limited purpose. But once India acquired independence from British rule in 1947, and subsequently we had our own constitution in 1950, the constitution guaranteed several fundamental rights under part 3 from article 14 to 32, and the constitution established two constitutional courts, one at the central level, that is the Supreme Court of India, and at the each state level a High Court. And the constitution expressly conferred the writ jurisdiction on these two constitutional courts, that is Supreme Court of India as well as all High Courts. Now, the Supreme Court of India enjoys writ jurisdiction under article 32, whereas all the High Courts enjoys a similar jurisdiction under article 226 of the Constitution. Now, if you look at article 32, particularly article 32 clause 2 expressly says that the Supreme Court shall have the power to issue directions, orders, writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto and certiorari. And it also says the court can issue such writs whichever may be appropriate for the enforcement of any fundamental rights conferred under the part 3 of the Constitution. Therefore, the Supreme Court's power to issue writs is restricted only to enforce fundamental rights. That is a very, very important, we could say a restriction on Supreme Court's power to issue. Then if you look at article 226, article 226 also gives a similar power to the High Court to issue those orders, writs, etc., but power of the High Court to issue such writs are subjected to a condition that a High Court can issue such writs throughout the territory in relation to which it can exercise jurisdiction. That means, the power of the High Court is restricted to its state's jurisdiction. Further, the notable difference is that the High Court can issue writs for the purpose of enforcing fundamental rights conferred under Part 3 or any other purpose. That means it could be for fundamental rights or even it could be for violation of any legal right. So therefore, if you analyze Article 32 on one hand and 226 on the other hand, there are few differences. Now, if you look at 32 is narrower compared to Article 226. Why I say that it is narrow in nature? Because you can approach to the Supreme Court for issuing of any writ only for the purpose of enforcing fundamental right. Whereas High Court, you can approach to the High Court for enforcement of a fundamental right or even for enforcement of a legal right. So in that sense, Article 226 is more wider compared to the Supreme Court's power. That's one difference. And the second difference is that Article 32 Supreme Court could issue writs and it could be applied the whole India. That means there is no territorial restriction on the Supreme Court to issue such a writ. However, on the High Court there is a territorial restriction, that means within the state to which the High Court belongs, you could enforce the writ. And then there is no such bar to approach to the Supreme Court directly. That means in case of violation of a fundamental right, Article 32 itself being a fundamental right under Part 3 of the Constitution, you could directly approach to the Supreme Court without going to the High Court. So that's an advantage with the Article 32. But a restriction is there that once your petition is pending in the High Court, you cannot approach to the Supreme Court. Similarly, you cannot approach to the Supreme Court when your writ for the same issue was filed before the High Court and the High Court rejects it. In such a case, your only remedy is go for an appeal to the Supreme Court, but not as a writ under Article 32. That means if a High Court refuses to issue a writ, you could approach to the Supreme Court not under writ jurisdiction but under appellate jurisdiction. Now, the next question that we are going to look into a little intensive, we should understand that who could apply for writs. As a law student, you already learned that there is a rule called locus standi. Locus standi means what is your standing before the court. That means unless you are the affected person, aggrieved person, you cannot approach to the court. So therefore, would the same rule apply in case of writs? That means if you have not affected by a decision of the government or by an authority, could you still go to the court? Because the locus standi rule says that the justiciability of the issue and the locus standi has two different things. That means whether there is any injustice is caused is a different one, and whether you have a right to question that injustice is a different one. So under the locus standi, what is important is that injustice must be caused to you, then only you can come to the court. But however, for example, the writ of habeas corpus and quo warranto strictly don't follow the locus standi rules. Any other person, not necessarily affected person, could approach to the court for issuing of these two writs. In addition to that, the introduction of public interest litigation into the Indian legal system, thanks to the Supreme Court for such a wonderful gift to the people, it relaxed the rules of locus standi. Therefore, now today practically for any writ, if you are a public spirited person interested in the public, could approach to the court for issuing of a writ. Of course, with certain restrictions, it is a very good move that writs could be asked by any public spirited person on behalf of the persons who are affected. So therefore, who could approach to the court? Technically a aggrieved person, but with the under the public interest litigation, any public spirited person could approach to the court. So, this is a simple, a small background about how the writs have developed, how writ jurisdiction has come into picture, how Indian courts exercises. If we looked at in India, the writ jurisdiction is exercised only by the Supreme Court and High Courts. So, therefore, let us begin with analyzing each writ, how, when, who could claim these writs.